Court of Boston, you're on air, give your attendance, and you shall be heard. On the Commonwealth of Massachusetts, the school is now open. Please be seated.
Good morning. Welcome to the Appeals Court. I am William Mead. To my right is Justice Englander, and to my left, Justice Walsh will be the panel for today's cases. If you haven't been here before, we have read everything, and it's my best advice to get right to the point. You needn't take, each side gets 15 minutes. We do not entertain rebuttal. You needn't use all of your time. Nothing argued in your brief that isn't argued here this morning is waived. With that, I'll call our first case, 22P536, John Tyler versus Melissa Tyler. Mr. Mateus.
Actually, Your Honor, Attorney Babcock.
Okay.
The record should reflect that, though somehow I guess I didn't water down to today's sheet. But yeah, previously filed my appearance and noted to the clerk's office.
Thank you. Go ahead, Mr. Pat.
Well, so Your Honors, I think as my brief makes clear, there's really three issues. One, a due process claim, which I think is very clear. My client was never given a trial. He was promised a trial. He was strategizing and holding arguments for a trial. The clerk.
Who promised him a trial?
Well, first of all, I would say the Constitution promises him a trial, the domestic relations promises him a trial, but I would also argue that there was clear communication from the court approximately 1 month prior to Judge Ward's decision that there was going to be a trial.
Are you suggesting that the Constitution requires something on top of a trial before a master?
Yes. Well, not necessarily in front of a master, but if there's a bifurcation and the parties agreed that there's going to be just one or two limited issues before a special master, and ergo everything else is going to be decided at trial, then absolutely a trial is necessary.
I'm not sure that's the way things work, and maybe you can help me with this.
Sure.
The judge issued an order, which I have in front of me, dated August 1st, 2019. And the order indicated that the master was appointed for purpose of hearing all the evidence in the pending matters. That's a quote. So now, are you saying to me that it's unconstitutional to have made that referral?
No. So as I mentioned throughout my brief, and I cite to the agreement, when bifurcation happened, the issues that were going to go in front of the special master were choice of laws and the enforceability of the prenuptial agreement. So those were the two things that were sent to the special master.
Well, but that's not what the order says. So I'm going to deal with the order first. You need to deal with the order because that's the order of the judge, right? And the order says, for the purpose of hearing all the evidence in the pending matters. So that's a difficulty I have with the argument. It seems to me you're saying, it's almost like ships passing in the night. You're saying, well, this was only referred for purposes of these things that I say, and I'm looking at the order saying, that's not what it says. By the way, I'm not making this up either. That's what the other side says, and that's what the master said when he was finally confronted with this argument.
Right, and so I think you have to take in light of the prior orders, which talk about the special master and the bifurcation process.
Why? Can't the judge change his mind? Her mind?
So the judge can change her mind, but if the judge is going to change her mind, as she did in this case, about a month after she said that she was going to get a trial, that's not fair to the litigant. Mr. Tyler, I think very reasonably, after presenting evidence to the special master.
If it's unfair, then wouldn't the way to deal with that be the moment that you saw this order for someone to say, hey, that's not what we agreed to?
Yes, and that's what Attorney Sparks did. That's what Mr.
How was
Tyler
that
did.
done? How was the objection raised to this order, which said, Judge, I thought that the special master was only going to address validity and enforceability of the prenup.
Absolutely. And Attorney Sparks made that objection, and in fact.
How? Where is it in the record?
So actually, I think the best place to look for it is in the appellee's brief. In the appellee's brief, there is a discussion between Judge Ward and Attorney Sparks, where Attorney Sparks is arguing why he has to have additional hearings and why he has to have a trial. So Judge Ward and Attorney Sparks had that.
When did that occur? Did that occur after the special master had already rendered all of his finding? It was special master or him? I'm sorry.
Yes, it is.
So special master issued two orders, right? One on validity and then one on enforceability. And when the special master entered an order on enforceability, the special master's order included recommendations as to the division of marital assets.
Yes, absolutely.
And the objection then came after that?
Yes. So Attorney Sparks argued, amongst other things, that in this particular case, there was demonstrable fraud on the part of Lady Morganite, a.k.a. Melissa Tyler, a.k.a. Melissa Taylor. And when in his argument to Judge Ward, he said, listen, we have presented some evidence of $172,000 that Lady Morganite has stolen over the course of the marriage, amongst other things, amongst other issues that we have had.
But
so
I'm still back on the argument that you've made is a constitutional argument. Okay? I mean, I think I also hear just sort of a basic fairness argument, maybe a process argument that's not constitutional, but I'm still back on how was that called to the judge's attention in light of the judge's order? And the answer that I hear now is if you look at the hearing before the judge with respect to the confirmation of the master's decision, you'll see us making this argument. You see was it made before that?
Yes, so Attorney Sparks also filed a motion to set objecting to the special master's decision. And in his objection to the special master's decision, he, amongst other things, argued the same thing he argued at oral argument in front of Judge Ward, which was, I was never given an opportunity to argue and present argument about the division of assets.
But that's that's after the special master authored a decision, right? So
Right.
when we go back to the order, as Justice Englander has pointed out, I mean, paragraph 2, to me, seems pretty clear, by agreement, giving the special master not only the authority to make findings about the validity and enforceability of the party's prenup under Florida law, but it says preliminary to his ruling on the divorce and counterclaim. So how can you act so surprised? I noticed in your brief you kept calling it a shock ruling or something. It's a new term of art that I've never heard of. I guess it's when your mouth drops and you're in awe and shock or something. I don't know. I missed that class in law school. So it's right there, preliminary to his ruling on the divorce and counterclaim. Taking of evidence. There were 89 exhibits or something of that nature, weren't there, introduced? I mean, it wasn't about what law applies, and I would imagine maybe just one exhibit would be the prenup. So I'm not really sure why I'd look beyond this very clear order that everybody agreed to until the outcome seemed to be a shock to your client.
Right, well, so I would, there's where I would disagree with Your Honor. I think if you look at the orders that were agreed to regarding bifurcation, there's a clear history where Attorney Sparks and Mr. Tyler are agreeing that there's going to be two phases. There's going to be the initial phase about whether the prenuptial agreement is enforceable and whether what the choice of laws are correct, and then there's going to be a second phase. And again, I think
once the prenuptial is enforceable, why doesn't that take care of the distribution of assets?
So that's a very good question, and so
Thank you. I worked hard on that one.
No, all glibness aside, it's central to understand that in this particular case, because of the fraud, I don't want to be too salacious, but due to the lying, cheating, and stealing of Lady Morganite and the abuse of the prenuptial agreement to obtain money and property and title to property that was just not hers. For example, 154 LC was 100% funded by John Tyler. 77 Everett Street was 100% funded by John Tyler. That's his specific money.
Both of those statements are inconsistent with what you have in your brief.
Well, so if I could just finish.
And inconsistent with the findings of the judge. So let's try to make sure that we're consistent in what we say.
Right.
The finding of the judge, which I think we probably are bound by, is
Yes.
that $50,000 came from the wife with respect to the 154, right?
No. So what the judge said, what Judge Campo said was, and by stipulation, 100% of the money came from John Tyler. However, $50,000 of that money would be credited towards Lady Morganite. So by stipulation, and again, it's in.
I don't understand the distinction. Why, if it was credited to Lady Morganite, isn't that because $50,000 of it was hers?
So basically, I think what Judge Campo is saying is that $50,000 of equitable interest is hers. The money was John Tyler's money. I mean, and to that point, John Tyler didn't appeal that issue. He could have and said, listen, actually 154 is 100% mine, not 89.7 or 90% mine, but he didn't. So I would agree with Your Honor 100% that at this point, that final ruling of 90-10 is done.
And in your brief, the indication was with respect to 77 Everett that some of the money also came from the wife's accounts or from joint accounts. Some of the money that went to 77 Everett.
No, well, so what ended up happening in that particular case, again, the wife used money from a joint asset to purchase 77, and then John Tyler, penny for penny, put his own personal money into the joint account. So there was this additional step that was done, but all of the money that paid for 77 Everett came from John, so Mr. Tyler, excuse me. So, but to circle back on the point, which is I think an essential point, Justice Meade, is that we have these in the prenuptial agreement, these necessarily conflicting provisions of the prenuptial agreement, especially when it comes to 4.2. So the prenuptial agreement 4.2 is John Tyler's property. It's, I think, titled John's property, right? So in that particular instance, it says if you fund something, if it's from your separate your separate investment or interest, all of it remains yours, John. If you take the money and you pay for it, then it is 100% yours, okay? It also says in 5.0 that if there is, both names are on the title, then it should be split equally. Okay, well now we have two pieces of property where 100% of it was funded by John, and the name on the title is different. So which of those two provisions?
Where is it in 4.2 that it says what you say, that if you fund something, all of it is yours?
Yep, absolutely. So I quote in my brief, I think, when I quote to section 4.2 in both my appellate brief and in my reply brief, I quote the essential elements of 4.2.
Well, see, the difficulty I had, I'm not sure it says that. And so, for example, I'll tell you why I'm not sure. Because I'm reading 4.1, which has mirror language in 4.2. All interests acquired at any time in the future by Melissa, regardless of the source of funds, shall remain Melissa's separate property. Now, there's an absolutely corresponding identical language in 4.2. So all interests acquired at any time in the future by John, regardless of the source of funds, shall be John's. What you're saying to me is something that sounds a little inconsistent with that, and so I'm trying to figure out the precise language we're relying on, because you're suggesting if John paid for it, it's John's. That's not really what this says.
Right, so it says John's separate property. includes his future ownership interests in other businesses and ventures. John's separate property shall also include any and all future shares of stocks, like, for example, in 154, options and other proceeds thereof from any business, venture, subsidiaries, franchises, partnerships, and others
Acquired by John,
in the future.
which means it has to be in his name, because I think that's the way the whole structure is. Whoever's name it's in gets it. If it's joint, it goes 50-50. Am I misunderstanding the structure?
Yes, I would say, Your Honor, that it's clear that especially throughout the operation of the marriage and also the communications between the parties, which are also in evidence, and I see I'm running very low on time, it makes it clear that when it comes to separate accounts, and Judge Campo, by the way, also made this clear, that first of all, there's a stipulation that all of the money came from John's accounts. So again, in Judge Campo's decision, he makes that clear. Again, there was an intermediary step. It came from John's separate property in Barclays Bank.
Talking about 154?
Yes. So it's again, John's
But
separate.
154 is held to be a joint asset, although John has 88 or 89% of it.
Right, but however, again, I'm just trying to answer, there's many points. So I'm just trying to answer your point about whether it's title or separate property that controls. It is absolutely, I think from my reading of 4.2, my understanding as well as the understanding of the parties and understanding of Judge Campo, that separate property includes funds. So if I have my separate property, my own separate money, right, and this is what the parties agreed to in the prenuptial agreement. They both had separate funds and they both had separate property that they were and separate business interests. If I take that separate property, my money, and I, pursuant to 4.2, keep it separate and intentionally fund it 100% myself,
And then title gets taken in her name.
So yes, and with respect to that,
Willingly, right?
What's
He
that?
knows.
No, title to the property, 154 Maverick Street, is owned by 154 LLC. But with respect to that, and again, I didn't even get a chance to really
That's
get
right,
into.
you're out of time. Thank
Yeah,
you.
but when it comes to the choice of
You're
laws.
out of time.
Oh, apologies. Oh, I see it's red. Sorry, I thought I had 50 seconds. Apologies, yeah. Thank you very much, Your Honors.
Ms. Prana Sweet.
Good morning, Your Honors, and may it please the Court. As my brother started to state, there are three issues in this appeal. One, that Mr. Tyler is claiming that he was denied due process. Secondly, that the court wrongly concluded that Florida law applies to the interpretation of the prenuptial. And third, that the Superior Court's ruling by Judge Campo is res judicata upon the probate court. If I could address the due process issue first, and perhaps some of the issues that both Justice Englander and Justice Walsh were raising, it is certainly our position and our contention that Mr. Tyler was afforded full due process. As this court has noted, the order issued by the judge back in August of 2019 made it very clear that the master was authorized to find facts, and not only to find facts, but that those findings of facts would be facts final. Those facts final then would be binding upon the court, and then the court takes the opportunity to apply the law to those findings of fact. The argument with respect to whether or not there was fraud, who purchased 77 Everett Street, how it was titled, all of that was presented to the masters. In fact, as noted, Mr. Tyler submitted—
Are there any findings on that?
I'm sorry?
Did the master make any findings?
Yes, he did.
You say that there were contentions and evidence put in along the lines of what the husband now says, that in fact 77 Everett Street was purchased from his funds. Did the master make findings on that?
The master didn't make specific findings on that, but what the master did find was that 77 Everett Street was Ms. Tyler's
But without any findings.
property.
So you say there's no due process problem because the order says that they were supposed to put in all the evidence. And then you say they were afforded a full opportunity and in fact did put in the evidence. And then you say, but there's no findings on it.
In the master's report, unfortunately, no, there aren't any specific findings on it, but when you read the...
In fact, there are no findings that I could see in the master's report with respect to any allegations of misuse by the wife of the husband's property to title things in her name.
No, there weren't, Your Honor, and one might suggest that if there were no findings of fraud or deceit by Ms. Tyler, that the master, by silence, did not find such fraud or deceit, or he would have...
So if I go back into the record, I'm going to find the same arguments, the same evidence that's now being contended by the husband about where the money came from for 77 Everett, for example, or the $172,000 that they say was his that wound up in her accounts. I'm going to find that evidence was presented to the master?
Yes, Your Honor, it was presented in Mr. Tyler's 200-plus affidavit and 89 exhibits that were presented
Okay.
to the master.
Okay.
Okay. So in light of that, we would suggest that he was afforded due process when the hearing came before the probate court Judge Ward with respect to the divorce, the entrance of the divorce itself. At that point, Mr. Tyler did raise objections, but we would suggest that at that time it was too late. Prior to that, both parties had, the master submitted his reports. Both parties had the opportunity to review it and suggest amendments to that report. The reports were then filed with the court. Both parties then had the opportunity to file objections to that report, which were done. And then the court, looked at everything, made its final determination. It entered its second partial order. And then
Was there post-trial, after the master trial, was there a post-trial briefing?
was there yes, I believe.
Did the...
I believe. Actually, what happened, Your Honor, I do recall now, is that the master, yes, gave both parties the opportunity to submit post-trial briefs, including a suggestion for the division of assets. Ms. Tyler did submit such a brief and did submit a suggestion of the division of assets. Mr. Tyler did not submit a suggested division of assets to the master.
So the difficulty that I'm having is it's like ships passing in the night and I can't figure out why. Because there is this series of contentions that you say actually was put into evidence that the wife had assets in her name that came from the husband's money. And there's no finding on it. And the husband's explanation for that is, we never thought that was going to be part of the case that was put before the special master. And your response to that is, I don't know why. It's in the order. We put in our stuff. We asked for our findings. But it's an odd sort of place to be, isn't it?
I would agree with you about that, Your Honor. It is somewhat odd. And I wish I could give you an explanation for it, Your Honor, but I really can't. I wasn't counsel below, so I really cannot give you that explanation. What I can say is that the master did make did find that the prenuptial agreement was valid. He did find it was enforceable. Once, Justice Mead, it would be our contention that once the prenuptial agreement was found to be enforceable, then you go back to what the agreement itself says in terms of the division of assets, and you enforce the agreement. And that would certainly be our position with respect to the question that you raised.
Well, let me ask this then, because I think I was about to ask right on that point. The implicit argument, I'm not sure it's explicit, from the husband's side is that if the husband were able to show that the husband's money was used to purchase, for example, 77 Everett, that even under the plain language of the prenup, a judge could award 77 Everett to the husband. What's the wife's position on that?
The wife's position on that is actually what Your Honor pointed out earlier in the argument, which is what the prenuptial agreement and 4.2 actually says. Thank you. It's actually 4.1 when it talks about Melissa's separate property.
From whatever source.
Right, from whatever source, correct.
So suppose that the wife literally just stole money from the husband, bought a house. He doesn't know anything about it. That's not, as I understand it, the facts with respect to 77 Everett. Your position would be the same? That, hey, tough luck. I took your money, I bought this asset, I titled it in my name, you can't get it back, and the evidence doesn't even come in.
I'm not sure that that would be my position, Your Honor, in that case, in that extreme case.
But then right, but then is this a matter of degree or a matter of kind? Because his argument is only somewhat different from that.
I think it is different in the case that Mr. Tyler knew that Ms. Tyler was going to be buying 77 Everett Street. He was aware of that. He contributed his money to that because he was aware of it, and he knew that that was going to happen. He also knew about the prenuptial agreement, which says what it says. So I would suggest that there is a difference and a distinction in that case.
So you don't dispute that 77 Everett was purchased with considerable amount of, whether it's all or some, of the husband's money?
No, I think that I don't dispute that. It seems to me that, that some of the husband's money may have gone to purchase 77 Everett Street.
And the harsh result of the prenup's language is that even though that's true, because it wasn't titled in both their names, the wife gets the whole thing.
Yes, Your Honor.
Okay.
If I could just move on to briefly to the other two issues that are before the court today, which is that whether or not Florida law applies to the interpretation of the prenuptial agreement. As we've argued in our brief, we believe that the court correctly determined that Florida law does apply to the interpretation of the agreement. The parties made that choice when they executed and drafted and negotiated this agreement. That choice should be honored by this court as it was honored by the probate court. There are, at the time that the prenuptial agreement was executed, that's where the parties were living, that's where they negotiated, they both had Florida counsel, that's where it was signed, so would suggest there was a substantial relationship. And would also suggest that the prenuptial agreement does not in any way violate fundamental Massachusetts public policy. And so for those reasons and the reasons articulated in my brief, would suggest that the court was correct when it decided that. And finally, Your Honor, is the issue of res judicata, which I think you're going to hear about in this appeal as well as in the appeal that is following this argument, and whether or not the Superior Court's decision is res judicata on the probate court and prevents the probate court from making findings different from the Superior Court. We would suggest, Your Honor, that the Superior Court rulings were not res judicata on the probate court. I think the Superior Court rightly recognized that it doesn't have jurisdiction over the division of marital property or marital assets, that is jurisdiction that belongs to the probate court.
The Superior Court had jurisdiction over ownership of 154 Maverick, right?
The Superior Court, I think, was very clear that for the purposes of determining who was going to manage the LLC, that it had to look at the unreturned capital contributions of both Mr. and Ms. Tyler. It did that. It determined that Mr. Tyler's unreturned capital contribution.
Wasn't it, in order to determine management, didn't it first determine ownership?
It determined voting rights, Your Honor, with respect to who had the majority
But the voting rights correspond directly to ownership as well.
They can.
Without the order of the probate court, the ownership in that asset was established at 8911, right?
Yes, Your Honor, by the Superior Court for the purposes of governance of the LLC. But the the Superior Court also made clear that the probate court could, in the context of the division of marital assets, come to a different conclusion when it considered the entire marital estate and the division of assets. So I think in the Judge Campos' decision, on several occasions, he was very clear in terms of exactly what he was doing and what the only issue before him was.
So you're saying, if I understand, that regardless of what was decided in the Superior Court, that John had 90% interest and that Melissa had roughly a 10% interest, that those could be redistributed in the probate court?
Yes, Your Honor, when it considered the entire division of the marital estate. Your Honor, if there are no further questions, I will rest on my brief.
I do, if my colleagues don't mind me going on. What was the situation with respect to what was going to be referred to the special master? The parties reached some sort of agreement?
I believe so, Your Honor, and I believe...
And there's a pleading that I'll be able to find that says that this is what the parties agreed to send to a special master?
You know, Your Honor, off the top of my head, I can't, as I'm thinking about the record appendix, I'm not, right now I'm not sure. I know that there was filed a stipulation between the parties that they would refer the matter to the special master. Off the top of my head, and I can look and not...
They don't have to agree, though, do they? Doesn't the court have the power to send it to a special master anyway?
Yes, it does, Your Honor. The court
Because
certainly does.
ultimately, as a matter of the process, the court adopts or doesn't adopt the master's findings, right?
That's correct, Your Honor.
Okay.
And
Thank
you are
you.
correct. The court, even without agreement, could have decided to send this to a special master.
Okay, thank you.
Thank you.
The next case is 23P152, John Tyler versus Lady Melissa Taylor Morganite. Mr. Adams.
Excuse me, Your Honors. I had to get the right glasses. May it please the court, I am representing 154 Maverick LLC.
Can you move that microphone closer to Mr. Adams?
Is that better?
Yeah.
Okay. So the appeal in this instance is of the denial of the motion to intervene. Now, On receiving the reply brief from Melissa Tyler's attorney, I was rather surprised. Her position seems to be that the probate court, the master right now, is merely valuing the LLC to determine whether there will be a buyout, a sale, or dissolution. And essentially, if that was the case, I think I still would have a right to intervene, but there certainly wouldn't be an exigent need to intervene if that was all that was happening.
Is it timely to intervene post-judgment?
I think the time to intervene is when the decision came down to deny the motion to intervene. At that point, it was ambiguous as to what the probate court was going to do regarding this division of 154. All of the cases that I have seen, a division of a corporation by the probate court in the course of a divorce is done by shifting shares. It's not done by selling its assets.
Well, did he order the assets, she order the assets to be sold or just divided?
No, at this point,
There wasn't a dissolution, as you're calling it, right?
the LLC has one property and it has one source of income. And there has been no valuation, no consideration of the LLC as a whole. The only action that the master, the probate court's jurisdiction at this point is trying to do is to sell that building. That is why 154 LLC has an interest to protect.
Well, let me get back to my question then. Did the judge order it dissolved?
She did not. She said to divide it.
Right.
It was ambiguous. There's nothing in the order that says how to divide it, on what basis to divide it. Again, this is dividing the LLC. We currently have, I think, 3 or 4 cases in the BLS court concerning the assets and liabilities of 154 and of each of the parties in this case. There's no determination of what's going to happen there. An LLC is an object created by the state. The legislature determined that it's going to be created in this manner, it will be operated in this manner, and it will be terminated in this manner. 154 LLC is bound to obey what the legislature has set up. And the legislature has set up that if it's going to be dissolved, there's a process for that.
Right, but there's no order of dissolution. I think that's what Judge Mead just asked you, right?
There is no order of dissolution.
Doesn't the probate court have the power to order the assets of the corporation sold for purposes of dividing those assets?
I don't believe so.
Why?
It would be a novel remedy. In all of the cases I've seen, if you have a corporation, there are 100 shares, the wife has 20, the husband has 80. If there's going to be a division, the shares are shifted, not the corporation's assets, because the corporation has obligations outside of that to the parties.
Right, well, it has obligations outside of that to...
The parties, in this case, we have a mortgage with a third party, we have contracts with third parties.
Oh, you mean it has third-party obligations?
Yes. And the effect of dividing the assets would be to dissolve the LLC. Who gets to keep the LLC?
Why do you say that? Is that by operation of law? If the assets of the corporation are sold, then it is dissolved as a matter of law?
If the assets went back to the corporation, no. But that is not evidently what is intended.
Okay.
What is intended is to take the assets and split the assets, leaving LLC with nothing.
Well, I'm not sure that that is inevitable. So basically, the way that I read it, and correct me if you're reading it differently, is that now they each own half of 154,
And I would agree.
right?
If-
So if 154 were a building, for example, it could be leased, and half the proceeds could go to her and half the proceeds could go to him. If 154 LLC was something else, then half goes, or the losses. So I don't see where we jump from 50% is yours, 50% is mine, to this means dissolution. And I'm not really sure exactly what interest you have independently.
154 LLC is an independent, legally independent entity. It has a right, the property belongs to it. It has obligations under the statute. It has an obligation under Superior Court, exclusive Superior Court jurisdiction. If it's going to be dissolved, it has to wind up its affairs. It has to
But why are we
satisfy.
talking about dissolution? We're just talking about division.
If the corporation is divested of its single asset and single source of income, it will be, to all effects, dissolved.
I'm missing the point here, and I think it's an important point that somehow escapes me. Can you,
We're looking at the language of what the judge ordered, right? What is the language of what the judge ordered?
Language is to divide 154 LLC,
To
its
divide,
asset and liabilities.
and he designate, I'm sorry, I'm trying to find the darn thing. That's a technical term. He directs the special master to be engaged in that process, right?
That's
Where's
the
it?
order that I've seen, yes.
in 154 wasn't around during that time, correct?
No, it was.
No, I mean, it was around physically, but it wasn't involved in the special masters.
Correct. The LLC's attempts to intervene were all denied.
Okay, so I guess my question is I keep going back to, why is it any different than anything else? 50-50. It still lives on. It's a very simple explanation in my book, but tell me why I'm wrong that a division of 50-50 just means that now there are two people that each own half versus one person that is in charge.
Well, the problem, okay, if the building is sold, and
No, let's just say that the building's not sold. The building's there now, it's Lady Morganite and John Tyler's
if,
154.
okay, if under Section 34, if this had gone under Section 34 and there was not a prenuptial agreement, so we say it's going to be 50-50 regardless of what the starting point was, we now have a deadlock in the operation because Mr. Tyler will be retained as the manager, even at a 50% interest, because there's no party that can dislodge him, no party that has a majority interest to dislodge him, so that it will continue, as it does, with John Tyler as the manager, to decide what happens to the corporation. That's what
Okay.
the statute requires. That's what the legislature intended. The option out of that, which is what Melissa Tyler is saying is happening in the probate court, is there's going to be evaluation. The parties can decide of their own volition what to do. One side will buy the other out, or whichever way. The buildings, its assets will be sold, or it will go through the dissolution process that this legislature has set forth. The problem for the LLC right now is that there is an order, or effectively an intention, to sell its sole asset and sole source of income. The intention does not seem to be to take that revenue and put it back into the LLC. The intention seems to be to take the assets of the LLC, give them to the parties as private personal property. One of the problems there that I can foresee is that that extinguishes the limited liability protection that both of them would have for the operation of the LLC. You've now changed the corporate property It's a private property. It's no longer an LLC property. And then, therefore, how do we resolve the issue of the limited liability?
Why is it that you are needed to assert these arguments? Because it seems to me that the most telling point, and I don't mean to belittle what else you've said, but the most telling point I've heard you make is that if this happens and the money, all the money of the corporation winds up with the individuals, perhaps it dissolves as a matter of law, they may lose their limited liability protections. And why can't Mr. and Mrs. make those arguments? Why do we need you? I mean, ultimately, this is an appeal from a denial of a motion to intervene.
Because the LLC is an independent entity.
Yeah, but it can only be directed by its managers, right?
Correct.
And one of those is sitting at this table. In fact, the only manager is sitting at this table.
And his duties, his personal duties, and his duties as a manager are different. His interests are different, his fiduciary duties are different, his position is different, his authority is different in those two positions. This is not, and the cases are very clear, there's a distinction, a legal distinction between an owner and the LLC, and that carries through issues of litigation and issues, for instance, there's separate counsel because there are conflicts between both of those parties and the LLC. The LLC is bound by the legislature's intent.
But you're not operating independently. I've never heard of that, and I have a hard, you're not HAL. You're not you're not the computer that's just operating on its own, right? You have to take direction. Someone hired you, someone's paying you. That person is the manager of the corporation. Maybe we can back up for a moment. I've found now the order. The order is, in the event the parties are not able to agree within 30 days on the method to divide the above assets, the court shall appoint a master. So that's all that the court's order says. Then we have your statement in the reply brief, which goes extra record, which says, but that's not what the special master is doing. The special master is not just dividing the asset. The special master is looking to sell the asset. Do I understand? Have I got it right so far?
Yes, and I have.
That's what has you concerned.
Correct. And the issue, perhaps I have to wait for the master to actually take action and then appropriately deal with that. But there is an interest that the LLC has at this point. And that LLC interest, regardless of the party's interest, I have a duty, the LLC has a duty that's separate from the interests and duties of the parties. We have litigation ongoing in the BLS2 court. If it's going to be divided or dissolved, that is where the legislature requires that process occur.
To your knowledge, has someone, again, we're extra record, so this is just answered this question and only this question. To your knowledge, has someone argued to the special master, hey, you don't have the power to do this?
Yes.
Okay.
The last point that I would make regarding Judge Campo's decision, there was a stipulation of facts by the parties. He made that decision as to the source of income, and under the LLC statute, the determination of ownership is based upon unreturned capital contributions. There is no legal or equitable title regarding ownership of an LLC. It's based, as the legislature intended, upon unreturned capital deposited into the corporation. That is a fact that Judge Campo found, and is a fact that the master adopted. And which
what flows from that?
the facts, the ownership of the LLC.
The ownership of the LLC until adjusted by a probate court that decides that it has the ability with the jurisdiction in front of it to adjust marital assets, right?
Under Section 34, but my understanding was that this was not a Section 34 determination.
Okay.
Thank you.
Thank you.
Mr. Babcock? Yeah, guess not.
Thank you. May it please the court. Justice Englander, I have I'm not sure if you and I are looking at the same order appointing the master. I'm looking at the one that's dated June 21st, 2021.
Well, what I was looking at when I just quoted is the partial judgment, second partial judgment of the court, entered April 15th, 2021.
So there is a subsequent order appointing the master in accordance with Rule 70 that was entered by the court on June 21st, 2021.
Okay?
That order, in paragraph 1, says the court appoints the attorney James Doherty of North Andover, Massachusetts, as a master with authority to effectuate the division of assets pursuant to paragraphs 3 and 4 of the second partial judgment docketed on 4/21/21. It then goes on to state that the master shall be provided full access to the named assets for all purposes, including without limitation, determination of value and sale or offset.
Is it your position that the judge has the power to appoint the special master to sell the assets of an LLC? All of the assets of an LLC?
It may, but if I can just finish quoting the order, it also says is that it's the master shall report his recommendations for disposition to the court for administrative review. So I think I would just quibble with your statement that the master has the authority because it does have to go back to the court.
Quibble taken. Does the court have the authority to do that?
Yes, Your Honor, I think after.
How?
Because, Your Honor, I think what the probate court has authority to do is, and while my brother has focused on the building, I think it's also important, because that is what the special master is focused on right now. That's not the only asset of the LLC. The LLC owns a liquor license as well that is of some value. I don't know what it is, but it is certainly of some value. And the master also has to take into consideration liabilities and indeed liabilities of the LLC when determining what that value is. So whatever net equity that either party may realize from the LLC would have to be determined after after all of those liabilities and the value of all of those assets was taken into consideration. And once you take into consideration all of that, then you get a net equity for each of the parties. And the parties themselves, Your Honor, I mean, they, as I stated in my brief, they could buy one another out, although it's my understanding that they have represented to the special master that they won't. But they could also determine between themselves that they want to sell the LLC to another entity or to another third party for that third party to take over the LLC.
Absolutely. They can buy each other out. They can sell the LLC. But if the special master recommends and the judge adopts that they will sell all the assets of the LLC, what happens then? And let me just tell you, the questions in my mind are, as a matter of law, does the LLC then dissolve? If so, does the probate court have the jurisdiction to essentially order the dissolution of an LLC?
I'm not sure that the probate court would have the jurisdiction to order the dissolution of the LLC. I think what the probate court has jurisdiction over is over the parties themselves and to order the parties themselves to do something or not to do something. I think what I would like to get back to is that what is at issue here is, as I think Justice Meade pointed out, or perhaps Justice Englander, that this is a motion to intervene as of right. I would suggest that the parties themselves are the ones who have the interest here, and that the LLC does not have an interest in the party's personal property, nor does it have an interest that's superior to the parties with respect to the division of the LLC. And that's all that's been, that's all that's right now at issue here is the division of the LLC. We don't know what the special master is going to do or recommend at this point. We realize, we do understand that there's been an appraisal of the property that has been done and that has been given to the special master. And now the parties are awaiting what the special master's next steps are going to be. But I would suggest that the parties themselves can protect and can argue, certainly can protect their own interests and protect the interests of the LLC, because ultimately, the LLC, their interests in the LLC are their own personal interests, which they are seeking to protect in the probate court. So I would suggest that as a matter of right, the LLC, at least at this point in time, doesn't have a right to intervene. And I would also...
The LLC moved to intervene before any of these orders were entered? Was the motion that we have is post-judgment, right?
That's correct, Your Honor.
Were there earlier motions that were denied? That's what they say in their briefs.
There was a very early motion, I don't have the date on the top of my head, Your Honor, but there was a very early motion for my brother, Mr. Adams, to appear on behalf of the LLC in the divorce matter. That motion was stricken or denied. Then there was a second motion that was filed on I believe, November 19th, 2020. And then it was on April 15th, 2021, that the LLC's motion to intervene was stricken from the record. That is before the divorce decree entered. The divorce decree entered on May 5th, 2021. Then there were three subsequent motions to intervene that were filed post-judgment.
Thank you.
So, again, as we've argued in our brief, would suggest that that those motions were untimely, and again, that the
I take it
LLC's
there was no appeal from the earliest denial?
That's correct, Your Honor. I would also suggest, as I think Justice Walsh has indicated, is that simply because the LLC may be divided 50-50, that does not constitute dissolution of the LLC. It's just a division of the LLC. My brother has also argued that because there are two members who may own 50% each of the LLC, that in some way that there is a deadlock here. The LLC has been operating for the past 4 years, and so I would suggest that hardly constitutes a deadlock of the LLC. So would
I think this may be clear, but the language of the order, this is what this judge, just speaking for myself, the language of the order says divide the asset. That doesn't seem to be problematic. What could be problematic is ordering something through the probate court that amounts to dissolution of the corporation without the attendant process that the statute contemplates for dissolution of a corporation.
That could be problematic, Your Honor, but if that's what the recommendation is coming out of the master that goes to the probate court, certainly both parties are going to have the opportunity to object to that recommendation before the probate court.
But your opponent on this appeal says, yeah, but they may not have a motivation to object, or they may not get that they need to object. And so the corporation needs to be present to raise its hand and say, wait, there's a whole lot of third-party creditors out there. There are people that we need to worry about. That's why when you dissolve a corporation, you do it this way.
I guess I would suggest, Your Honor, that I don't think that either Mr. Tyler or Ms. Morgan, given the history of these proceedings, would fail to object to something that they didn't agree with or fail to file an appeal given the proceedings that have gone on here over the past years. But again, there is the opportunity, and I suppose, Your Honor, that if that happened, the LLC probably would file some sort of motion to intervene in that case and argue its case there, again, raising issues that, may have been brought before this court at this point in time. But I don't think we're there yet, Your Honor, since we don't know what's going to happen and what the special master is going to recommend and what the parties may or may not, come to an agreement between themselves. So while I hear you and I understand your concern, I'm not sure that we're there yet, Your Honor, and I think that may
When
be in
that
the future.
happens, you're going to get up and say it's too late, it's post-judgment, and I understand your point, but I'm not sure how persuasive it is under the circumstances.
The circumstances may be different, and the criteria for intervening post-judgment, while it is a high standard, at that point maybe it's met. I don't know at this point as to what would happen in the future. The other thing that, again, sort of thinking about if a sale were to be ordered, Your Honor, is that rather than the proceeds being distributed to the parties directly and immediately, maybe the recommendation is, those proceeds go into escrow for the benefit, of the LLC to pay off whatever contracts, liabilities, et cetera, they have, so that, those don't go unpaid or unrewarded, and then again, whatever is left, whatever the net equity is, will then subsequently be determined and distributed to the parties. If there are no further questions, I will rest on my brief.
Thank you.
Thank you.
Is he going to argue on this one?
I think we're done. Okay.
May it please the court, now as the appellee, Douglas Babcock for Mr. Tyler. I am slightly disagreed with the appellant and I think significantly disagreeing with my fellow appellee. In the end, whether the division and all these other issues are moot because of Judge Campo's decision determining it was 90-10 or 89-11% split, and because of the raised effect of that decision. And I know my sister has mentioned Judge Campo's decision several times. She's mentioned it in her brief, but I would implore your honors to look at Exhibit 22 and specifically page 278 of the appendix, or just listen to me now, where she consistently leaves out the most important part of the decision, the last sentence of Judge Campo's decision, where he says that subsequent division by the probate court can be done, may be done, only subject to Section 34 equitable division. He then cites two cases, Colloon v. Rawlings and Denninger v. Denninger, both of which where there was no prenuptial agreement and there was a Section 34 division. And he makes very clear, Judge Campo in his decision, that the probate court has deferred issues regarding ownership of 154 LLC to him, and he defers back to the probate court only pursuant to Section 34. And
I don't understand that. Your argument is that the Superior Court judge
Yes.
in some way was limiting what the probate court judge could do in deciding the divorce. That's the argument, right?
absolutely, because
What power does he have to do that?
because the probate court gave him the power. So the probate court ceded ownership of the discussion of ownership of 154 LLC to the Suffolk Superior Court. Both parties agreed that that's where litigation of ownership of 154 LLC would continue. Now, my sister keeps saying, well, the point of the Suffolk Superior Court litigation was to determine who was going to be the manager and what ownership shares were. And while that may be the point, Haycock v. Haycock makes very clear that the issue preclusion is if the issue is addressed in a previous court, that's the final decision. So the issue of ownership was a necessary decision made by Judge Campo. So Judge Campo looks at the LLC.
Decides as of X date that this is what the ownership is. Then we have an ongoing divorce proceeding. We have a judge with jurisdiction over the marital assets. Judge decides how to split the marital assets. It's not bound by, every piece of property that comes to a probate judge has an owner. He can change the ownership. He can change it pursuant to Section 34, he or she can change it pursuant to a prenuptial agreement, right?
And in this particular case, Judge Campo made clear, since we have litigated and had a trial with respect to ownership, unless there is a subsequent equitable division to 34, and unless similar to Calhoun v. Rawlings or Denninger v. Denninger, unless there's an equitable division that's made, this is the ownership. This is the final decision as to ownership. Final decision as to ownership is 90-10. But by the way, in the appellee's brief, they make clear that Judge Ward has a discussion with Attorney Sparks that they quote, where Judge Ward says, I'm not going to get into Section 34 considerations. This is not a Section 34 case. Consequently, Judge Campo's 90-10 split is the final decision.
Is it possible that Judge Campo, who was not sitting as a probate judge, thought that the division would be pursuant to Section 34 without knowing that there was a prenuptial agreement that had to...
He specifically mentions that in his judgment. In his judgment, he says, I understand that there's a prenuptial, there's an argument about the enforceability of a prenuptial agreement. And that is exactly why he says, I understand they're fighting about a prenuptial agreement. If it's decided pursuant to a prenuptial agreement, then the split of 154 is done. It's 90-10. If there's however, there's an equitable division, then Judge Ward...
Telling me that the prenuptial agreement and the meaning of the prenuptial agreement was argued before Judge Campo?
So absolutely arguments by both parties were presented to Judge Campo about the prenuptial agreement, and Judge Campo says, I'm not getting into the prenuptial agreement. I'm just determining ownership of this particular asset, and if there is a subsequent equitable division, again, pursuant to 34, then that decision can be made. But there was a 2-day trial, and throughout the course of that trial, those arguments were made. And also, I would add, as Haycock v. Haycock makes clear, it's not only what issues were raised, but it's those that could have been raised. And Judge Campo made that decision of a 90-10 split, 89-11 split, and made very clear that, again, the probate court may be able to decide it pursuant to Section 34 if in equity, then that's the way the marriage breaks down. But if it's a prenuptial agreement situation, then this is the final decision. It's 90-10. We're decided. And as a consequence of the 90-10 split, the 154 doesn't need to intervene. If there's a 90-10 split, then what the division of assets and so on and so forth would be made completely moot. Mr. Tyler.
That makes the argument of intervening even less than. It's like if I win, I don't need 154 to help me win.
Well, so I appreciate that 154 has its own legal obligation. When 154 found out that it was going to, so 154 operated for years, as everyone did. John Tyler paid 90% of the taxes for 154. He paid he made all the decisions. Everybody involved in 154 LLC acted as though, for years, that John Tyler was the 90-10 owner. When the probate court, again, has its, decision, it says, hey, communicate to the parties, we're going to have a trial, then suddenly says, nope, just kidding, we're not having a trial, and I just decided to split 154 50-50. 154 then says, well, now I have to intervene. So if there's a 50-50 split, if that is correct and accurate, then yes, 154 has to come in, because now you have a deadlock situation. Now you're trying to divide assets of a corporation, which the probate court doesn't have jurisdiction to do. All manner of problems arise if that is upheld, but luckily, we don't have to uphold that. Res judicata solves this problem for us. There's a 90-10 split, and consequently, we don't have to worry about the 50-50 deadlock and everything else. And I think 154 recognized that there was a res judicata effect. 154 even mentions that it's in this place, but it's needing to intervene in case that somehow that 90-10 split isn't upheld. And so, again, I think Justice Englander was correct before when you indicated, listen, to say you have to wait for the special master to order the sale, and then the sale of the asset happens, and then, by the way, there's about $1.6 million in taxes due to the parties, and there's a myriad of legal fallout that happens, then 154 gets to intervene. Well, by then, it's way too late. And I think, consequently, if there was going to be a 154 split, a 50-50 split, then 154 would have to intervene. But there isn't. There is a clear 90-10 split by Judge Campo. And if you read, really, it starts his 10-page decision absolutely conceptualizes and addresses the fact that there's this ongoing divorce proceeding, that there's an argument about the prenuptial agreement. And again, he says, if it's a prenuptial agreement that rules, we have a 90-10 split. If it's an equity issue, then and Section 34, then the probate court can do what it will. And everybody agrees there was no Section 34 division. It was absolutely both the orders of the first partial judgment, the second partial judgment specifically cite, we are making this division pursuant to the prenuptial agreement. The Judge Ward states on the record, I'm not even getting into Section 34 issues. Section 34 did not apply, ergo Judge Campo's decision is a final decision due res judicata. And to be clear, it's not an unfair result for several reasons. First of all, Lady Morganite was there, had ample opportunity to, and over days of trial, represented by counsel to make all of her arguments, and she did. And she did so, one. Two, as I mentioned, 100% of the capital contributions were John Tyler's. She was lucky to get 10 or 11% consideration from the judge. And finally, she didn't appeal that decision, ever. So, and years went by where the 90-10 split was the operating, understood determination of the court. So, I mean, I think put most succinctly this way, Melissa Tyler started the Superior Court action. The probate court deferred to the Superior Court to decide who was going to own 154. All of the parties agreed that that was the way to do it. They had a trial. Judge Campo envisioned what was going to happen subsequently, left a window open for a Section 34 decision, but otherwise said, this is my final decision. The parties accepted that decision, and neither one of them appealed that decision. I don't, and again, I think, if you have any other questions for me, I'm happy to answer them, but I think that I would rest on my brief. It's
Okay,
just,
thank you.
thank you.
Thank you all. We'll take this under advisement. With that, I'd like to thank our court officers, our clerk's office, our law clerks, my panel, and the excellent timekeeper, and we'll stand in recess.
All rise.
It's a slow recess.